for those of you who aren't lawyers, you may not be aware that the attorney-client privilege isn't absolute in the sense that there's what's called a crime-fraud exception, where the privilege does not apply to information that the attorney has about some criminal act that the client is contemplating committing in the future, or some ongoing criminal activity. But I think the point made about the attorney-client privilege is a good point. I mean, we have an attorney-client privilege, and I guess the question is, why don't we also have a comparable absolute journalist privilege? And I've thought about that, and I don't know if I have a very good answer to that. I guess I would answer that primarily by saying that in the case of the attorney-client privilege, the privilege is for the protection of the individual who needs legal advice to defend against some criminal charges that are brought against that person. And it arises out of the relationship, the attorney-client relationship. In the case of the journalist, I think the problem there is that how do you leave it, if you create an absolute privilege, you're leaving it to each individual journalist to decide under what circumstances do you promise confidentiality. And once the promise is made, the privilege is now irrevocable, regardless of how ill-considered the promise may have been, or how, weighing all the factors, how well advised the court might think the promise was. The promise comes into being by the reporter's decision. And there would be as many standards for determining under what circumstances confidentiality will be conferred as there are reporters. I think probably different reporters would look at it differently. There are also different levels of reporter. There are some reporters who are very responsible, and others maybe not so much, who are more intent on maybe getting a story or a scoop. And you also have the problem, I think, that the reporter may not be aware of all the relevant facts at the time the promise is made. What happens if the reporter later finds out that this information that was given to the reporter was obtained by a breaking and entering, or an illegal wiretap, or some other illegal act? The reporter is now in kind of a bind. He or she has promised confidentiality and now learns other facts later that the reporter couldn't have known at the time that might have affected that determination. So there are a number of reasons why I think it's not good policy to say that the decision made by a reporter on the spur of the moment should determine whether or not the privilege exists without being subject to be revisited later on.
I think it's very analogous to the attorney-client privilege. If the client involves you in a crime, or is going to, same thing with patient-therapist privilege. I think any journalist knows that if somebody tells you they're going to go out and kill someone, that's going to put you in a bad position. But can you imagine telling that to your therapist, that when I leave here, I'm going to go kill my husband? That's what I'm going to do. Can you imagine the therapist saying, well, can I get a waiver from you to go to the police and tell them what you've just said here? No, I think we all intuitively know. I don't think it's about being a journalist. I think it's about being a human, and that we all know, that you shouldn't, if somebody's going to kill someone, that crosses a line. And I think that we all appreciate that without that having to be stated. And I think trying to outline all the conditions under which somebody will surrender is as ridiculous as posting a placard in a confessional booth saying, warning, if you tell me that you're going to kill someone, you don't need to do that. It does not serve a purpose.
Simply that the analogy to attorney-client is very attractive and has force, but without remotely suggesting the existence of a hierarchical relationship at all, the fact of the matter is that the attorney-client relationship and the attorney-client privilege are absolutely infused for hundreds of years with the overlay of the court's regulation of the legal profession. Lawyers take oaths of office in every state in this country. And again, journalists have ethics, and there are regulatory sort of associations that try to provide ethical norms. But the fact of the matter is The analogy tends to break down when one considers the background, the deep, important background of the court's role in regulating the legal profession and what lawyers are supposed to bring, sometimes fail, but are supposed to bring in the professional relationship that they have with their clients.
But one more thing, I'm sorry, it's the relationship that has to be protected, and for the same reason that you have to be able to feel free to tell your attorney things, that attorney cannot zealously represent you without knowing all of the facts, just like a journalist cannot zealously news gather unless they have all the facts. If anyone withholds, it abuses the whole function of that privilege.
One quick observation before we go to that question, and that is just, I'm also struck by the fact that in a privilege for clergy, lawyers, doctors, et cetera, the benefit derives, as we said, not only the ownership of the privilege, but the benefit derives to the individual, not the actor, if you will, the doctor, the lawyer. Without trying to create a hierarchy, for journalists, the benefit derives to society rather than the individual who has got the privilege. So I think there is a difference in setting that up when we're analogous to these other things. But if I were going to draw a hierarchy, society's here, individuals there. But we'll go to this question there.
Yeah,
and I think that will have to be it, unfortunately.
Yeah, Stuart, Karle, I'm the general counsel of the Wall Street Journal. And I wanted to tie a couple of these things together. I mean, Judge Torres and Judge, every client who walks in your door as a lawyer, the privilege attaches because that's part of your function. The relationship between a journalist and a source is much more contentious than that. And in fact, most journalists have every incentive, because every story is better if the sources are identified. And one of the assumptions here is that somehow there's this desire to go out and find confidential sources because they're better. They're worse. They're always worse. Every source has a bias. If you can disclose that bias, even by giving the name, you're much better off as a journalist. And one of the things I think sort of you skip over is you decide that lawyers have some sort of additional rights or should have additional rights, or there's some sort of something fundamental there, is in fact they're not choosing their clients. I mean, they will ultimately, but basically anybody who walks in the door and can pay is potentially a client, and that relationship attaches, that privilege attaches. A journalist making that choice is in fact a difficult choice for most journalists. They have every incentive not to make that choice. And I think you have to take that into account when you look at journalists and sort of, you've got this conception, I think, that's sort of running amok out there, that journalists are in fact running amok, that they're out there and they're trying to make these deals and put themselves in this jeopardy, weaken their stories, and they don't. It's in fact quite the opposite. And I think when you look at, should you protect this relationship, should it be absolute, you should take that incentive into account, because it's there as a matter of practice, it's there frankly as a matter of law when you get into libel cases. And I think you're overvaluing, in a sense, or undervaluing that incentive and the professionalism of the profession and the incentives it has.